basically a mark that you use or that you intend to use in relation to goods or services that you want to use to distinguish your goods or services from the same type of goods or services of other people. Okay, so in order to have trademark protection, I would say that you have to register. The action for passing off an unlawful competition that you use when you don't have a registered trademark, there are some things that you have to prove. That is actually quite difficult. You have to, for example, you have to prove that your trademark has a reputation. And when you're a small company, that's very difficult to prove. Or if your trademark is not necessarily widely known, then it's difficult to prove. So especially for young companies, it is very important that you register your trademark, because that way you don't have to prove that you have a reputation, you don't have to prove that you have rights in the trademark. If someone wants to dispute that you have rights in the trademark, then they have to prove that you don't have the rights. In the requirements for registration of a product, it must be distinctive. So a trademark can either be inherently distinctive, in other words, it is distinctive because it's different, or it can be distinctive because you've used it so much in relation to your goods or services that people have come to identify it with you. And then it can't be just descriptive. So you can't register a trademark for a good example is like Apple. Apple for a computer is not descriptive for a computer because it has nothing to do with a computer. But for juice or for sweets, it is descriptive because it can describe the flavor of it, or it describes a fruit. It can't be just descriptive. It can have descriptive elements in a trademark, but it can't be just descriptive. So it can't be something that's customary in the current language or in the trade practice. Something everyone uses. You can't exclude someone from using a name or a phrase that they are using anyway. You have to have a bona fide claim, that's a good faith claim to proprietorship. That just means you can't steal someone else's trademark. You must have an intention to use it. So you can't just register a trademark just to stop someone else from using it. You can't register the national flags, memorial bearings, and state emblems, and then you can't register something like this, the copyright symbol, the registered symbol, and all of that. So that's where Cell C wasn't so smart when they adopted that Cell C thing. That well, they can use it, but they're not going to stop someone else from using it. It can't be the same or confusingly similar to something that's already registered, or that was already applied for, may not be registered yet, or that someone else used extensively, that they've started using already. You can't take a well-known trademark for yourself. If the trademark is well-known, they have a bit more protection. Like you can't open a shoe shop and call it McDonald's, because you're going to take unfair advantage of that good big reputation that McDonald's has. And so even if it's not registered, even if it's registered for different services, and even if they don't have business in South Africa, if they're famous worldwide, then the law protects them.